So we start? Yeah. So we are discussing today everything about judiciary. Again, for 2025, this might look a bit more fast-paced because this is Smash Mains. So we're trying to address the mains wala part. So a lot of the factual data, if you're not well aware, in due course of time, we'll get through it. So that you should not worry about that. So when you're talking about Indian judiciary, what are the dimensions that you think like are necessary? Like from a Lakshmikant point of view or prelims में जो भी आपने पढ़ा होगा judiciary से related, what are the different dimensions that comes to your mind? Yeah, independence of judiciary is one angle. What else? Yes. What else? Collegium. What else? Yes, separation of power. Yes, the type of judiciary we have, integrated, independent judiciary as well. But apart from that, like judiciary is about what? So first is like justice, principles of justice. And then everything that now we discussed. But apart from that, we have the Supreme Courts and High Courts and the institutions who are delivering this justice. So issues regarding Indian judiciary is one of the things that you have to focus. Judicial reforms are one thing that you have to focus. Abhi very famous in news is collegium system, judicial appointments, the retirements of judges, the removal of the judges, they also become very important. Apart from that, what is important is legal education, alternate dispute resolution, representation of women and disprivileged community in judiciary, technology in judiciary, and apart from that, we have PILs, judicial activism, the judicial review, judicial outreach. So basically everything that you would have seen in the index page of Lakshmikant or any book that you would be referring for prelims, those are the major areas for which you should have notes. That's what I'm saying. So when talking about judiciary, these are the different constructs around which you can have a question. Last year on judiciary 2023 GS2 we had two questions. One was on judicial independence and one was about I think NALSA, which is Legal Services Authority, and giving free legal aids and legal awareness in general. So there was a question on that. And every year, if you see, for the last 10 years, I think there are 8 questions have come from judiciary. So it becomes an important topic. So you should have good amount of content for this. But in judiciary, there will be overuse of court judgments and articles. So you should be more thorough about this and add as many court judgments as possible and articles possible in judiciary topic. Again, for judiciary, what happens is that a lot of people use content in terms of article through the introduce and conclusion to keep it a very basic conclusion. Keep 2-3 quotes ready for judiciary that you can keep as a ready-made quote conclusion ready. I'll just add one, and in the smash note there will be a couple of them as well. This is a quote by a very famous Supreme Court Judge P.M. Bhagwati, who is basically called the pioneer of PIL, public interest litigation, everything. So this encompasses the entire idea of Indian judiciary. So this is a very ready-made quote. Before we go on to the every body content, I want to give you कि किसी भी judiciary पे you can have few way forwards and conclusion के points ready, because whatever you see कुछ भी आपको दिया गया होगा, whatever questions you would have gotten for Indian judiciary, either that will have an issue or some criticism to that, and then you give a constructive point. So things that you have to keep in mind for way forward, one is ADR, alternate dispute resolution, technology in judiciary, judicial reforms, and Article 39A. What is Article 39A? Legal aid. Yes, or any committee recommendation. Two famous committee here becomes important. One is Mullah Committee and one is Malimeth Committee. We have few more as well, but these are the ones who have talked about a wide range of judicial stuff. So this becomes your ready-made way forward and conclusion for any judiciary. You can have it. And this is basically, we can have a separate lecture on what does Mullah Committee and Malimeth Committee says. But now I'm giving you content and ways how you can make your answers better. So we'll not go in detail and talk about everything. So having done this, like your introduction, you have your articles, any quote, or conclusions, we have a way forward. Always 39A becomes a very staple in judiciary, justice, legal wale question that you can put. First, what comes to us, what does the role of judiciary does, and I'll go a bit abstract so that this content you can use in a lot of answers. What do you think? What are the role of judiciary? How is it helping Indian democracy in general? Can't hear. Yes, putting the rights of citizens. What else? Yes. Constitution safeguard. But these are very, the way you are now thinking, it's very ad hoc. You should always, you should keep this in practice when you're brainstorming an answer and writing a mains answer. Have some constructs ready in your mind so that it becomes easier to answer a question in an exam-bound manner. Always go through the different tenets of constitution and see that through that lens, judge what is the role of Indian judiciary. When you talk about constitutional safeguards, I have this forms as a guardian of the constitution. I have rule of law. I have fundamental rights, as you guys mentioned. Then what are the other tenets? I have separation of power. I have institutions, as in constitutional institution. Example, governor. Judicial review. Reinterpretation of constitution. This is a way, whenever you are writing an answer and you're giving a flow chart, always ensure when you're putting your arrow, always put numbers in that. Otherwise, it just feels as if to an examiner it's a diagram. But when you're numbering it and you're putting a quantity to it, it adds on to the psyche of the examiner. How can we? Achha. This should be social justice. Ninth would be checks and balances. What? Yes, vulnerable section, which is basically social justice. Yeah, but fundamental rights are like everything, but you can have a social justice angle, another point. This is being progressive in nature. I'll discuss how can like put a value addition in every of these points. First, we had the guardian of the constitution. For that, we have the formulation of basic structure. Kesavanandi Bharati case 1973 that encapsulated the idea basic picture cannot be altered. Second, we had the rule of law. Everything around that, right to equality, protection of rights. We had a case of A.K. Gopalan case, which was for the preventive detention wale case pe, where even in times of emergency, the basic rights of and natural rights of the citizens cannot be taken away. Then third, we had fundamental rights. Fundamental rights, we had a lot of judgments around that. Anything that you can recall? But Puttaswamy case is not for protection. It was in a way, you can add that point, but there are a lot of rights which are directly protecting a right. Puttaswamy case was a reinterpretation of the fundamental rights. Maneka Gandhi case could be also, but it's like adding on to expansion of Article 21. There's a famous case on Shriya Singhal case where the IT Act, there was one provision which was taken away. So right to freedom of speech and expression was restored. Similarly, there was a case, very old case, but Ramesh Thapar case, 1950, which was for freedom of press. So these are for fundamental rights. Similarly, then we talked about separation of power. For separation of power, again, we had a judgment which was Ram Javai Kapoor case. Also, Indira Gandhi versus Raj Narayan case, which is very important. That is also for separation of power becomes important. For checks and balance also, you can have the Indira Gandhi and versus Raj Narayan case. That also helps for separation of power. Next, we had safeguarding the constitutional offices like governor. For governor, we have a lot of provisions. BP Singhal case, Rameshwar Prasad case, Nebam Rabaiya case. So these are the ones for governor. Then we discuss about social justice. For social justice, we have Naftez Johar case, removing the criminalization of homosexuality. We have Nalsa versus Union of India giving transgender rights. For women, we have a lot of cases, Vishakha judgment. Similarly, Shahbano case, Shahrabano case, all those things for women, also for social justice. What else we discussed for, I think we discussed for broadening scope. Broadening scope, you can put Maneka Gandhi case Puttaswamy case, where there was a reinterpretation and broadening of one principle. Another point, last, we had something called the judiciary becoming progressive in nature. So, judiciary also have reformed themselves. For example, earlier, the principles on which punishment were given was repressive in nature. Now that has turned into restitutive and reformative. So this is a very good phrase, like from repressive to reformative. That is something which is seen in the judgments of custodial deaths. Bachchan Singh case or Machi Singh cases, where the phenomenon of rarest of rare. The court is saying at the rarest of the rare cases, the capital punishment has to be given, and also they are advocating for socio-psychoanalytical tests. So in this way, the judiciary is also reforming themselves in which they are operating. So these are the brief ideas you have to always keep in mind when you are answering any Indian judiciary questions. Safeguarding the constitution, separation of powers, constitutional offices, social justice, checks and balances, separation of powers, being progressive in nature, and so on and so forth. You can add a lot of dimensions. Say federalism also you can point out. You can point out other things, but these are the basic tenets in which you can have analyzed through various lenses. And keep it at one place. You write it at one place. So, and when you actually write an answer, through these points, it becomes easier to analyze as well. Before that, I would want you guys to be thorough with few articles for Indian judiciary, which you can quote at multiple places. But it's important to keep that in one place. We have the first 124 and 214. This establishes Supreme Court and High Court respectively. So if there's a direct question in Supreme Court, something XYZ, and you have no other introduction to give, instead of giving a plain generic one, you write Article 124. Or even though you're giving a plain generic answer, you're writing, like if the question is how is Supreme Court has evolved across the years, let's say. You're writing Supreme Court has had been XYZs, you're writing one line. But in bracket, if in writing article established through Article 124 or High Court P 214, then that adds on to the value. So overuse as many judgments, as many relevant articles possible. That will make your GS2 answers look like it's a polity answer and not a generic one. So this is one which is important. Article 13 for judicial review. 32 and 226. This is for writs. Supreme Court and High Court respectively. The fourth one, what becomes essential is 129, which is contempt of court. Court judgment for this Prashant Bhushan case. We have 136. This one you must have read for prelims. 136. Yes, special leave. Then we have 139A, where it tells that it can transfer the cases from elsewhere. Two important, 141 and 142. Very, very important one where you can quote a lot of places. 141 is by Supreme Court judgment is binding on everything, binding on all courts. And 142 is complete justice. Very important 142 at least. Then, more or less, I think these are major important articles that you can have. And so, whenever also judiciary questions, see through these lens where you can analyze the questions and make answers as well. So, we'll discuss the relevant court judgments for this also. But before we do that, we'll do this through a PYQ. I'll show you that how you can use these articles in a more profound way. We'll talk about issues with Indian judiciary. Always have a structure ready for it. How you will have it. Do not just keep on write random statements. But if you can figure this out in various criteria, various categories, that brings more structure to your answer. And then it makes the life of the examiner easy. The bottom line of getting better marks is make the life of the examiner better and easier, so you will be awarded more marks. So serve it to him, I have written, I have covered all points. And how you do that? When you structure your answer better. And structuring does not happen then and there. When you have brainstormed a lot of dimensions, a lot of structures, constructs, then it becomes easier to reproduce them in the paper as well. So now also, if you do not have time to write a lot of answers, for that at least brainstorm, write the semi-subheadings. That will help you to at least broaden your horizons in which you can analyze. So first is like a structural issues, like the very fundamental issues with Indian judiciary at the point. One is a pendency of cases and frequent adjournments. And always write a data, like when pendency, write greater than 5 crore cases pending. It's always better to put the source as well. But if something which is a very common data and you do not have a source for that, do not shy away from writing that. But if it's a very lesser known fact, then it becomes important to quote the source. But it's a very wide known form that 5 crore cases are pending. If I don't know also the source, I'll write greater than 5 crore cases are pending here. Then we have the government being the major litigant, like basically is one of the parties to the court cases that goes on. Third, we talked about vacancies. We have 1 out of 34 in Supreme Court. We have around 35% in High Court. And we have around greater than 20% in subordinate courts. We have corruption in legal field. Like whenever writing a point like this, like again, if you do not know any data or any report, so you just write ki what is X rank in corruption perception index. I think now we are at 90 something, 93rd, but get it verified. What is the, by the time you're writing the actual, if you have gotten a new report of that, any rank, so do that. So what I'm saying, if you do not have a direct data also to it, it's okay if you're writing thoda relevant data also around that as well. Then we have representation. When I talk about representation, it could be women and it could be the disprivileged community. Yeah. So women in High Court, there is only 13% representation of women. And for disprivileged, 80% of Indian judges come from upper castes. So your micro notes should look like something like this. You have everything at one place. And then it becomes easy to reproduce in your answers as well. So this is one angle. But you have how many points? 1, 2, 3, 4, 5 points. Yahi. But this could come under structural issues in one. Then we have the administrative issues, day-to-day functioning and in things like that. Anything that you can think about in the functioning? Yes. The master role. Roster and role, anything. So it's basically how the entire timetable of the courts is being done. And instead of like in collegium now you have like multiple judges involvement. Here only the Chief Justice is responsible for doing this. And there have been a lot of court cases as well for this, where there has been recommendation to change this as well. I think there was a case, Subramaniam Swamy versus Union of India, which had similar things suggested. But again, very, very basic appointments. Article 124 again. About post-retirement. Lack of cooling period. Yes, RTI too. Although Chief Justice of India's office comes under RTI now, which has been RTI, yes, Subhash Chandra Agarwal case. Under this case now, the Chief Justice of India's office comes under RTI, but the entire scope of RTI is not very widened in Indian judiciary as well. Then we have Uncle Judge syndrome. Use these kind of phrases when you're writing an answer. Uncle Judge syndrome is basically the conflict of interests, because Indian judiciary is accused of having a lot of nepotism, a lot of kith and kin. The judge would be the uncle, and its side their kith and kin would be the lawyer. So there's a lot of accusations for that, which is called Uncle Judge syndrome, basically for the nepotism which is there. Then we have contempt of court. We just discussed contempt of court. Which article?
129.
Yes. 129, right? Or 129? 129. Yes. So contempt of court is basically the court can punish if they find that somebody is trying to criticize in a very extreme way. There are a lot of ambiguity, it's not defined as well. So that could harm the right to speech and expression as well. So that could also be one of the issues with Indian judiciary. Yeah, that's not administrative. That you can have a different point altogether. Like you cannot club that in administrative. Judicial overreach is a separate concept altogether. So that's a different issue. But that's a technological point of view. So you can do that another point. But this master roaster, that point was, this was not Subramaniam Swamy, it was Shanti Bhushan case. Subramaniam Swamy, I think, was VVPAT. There was a case on that, but this master roaster issue was highlighted in Shanti Bhushan versus Union of India. So these are the administrative points. We had like 5-6 points on administrative. Now, as you said, technology. Always in any GS answer, keep in mind, if you're not getting points, always see it from a lens of technology, see it from a lens of institution, like koi institutional bodies hai, see it from an angle of policies or legislation and any laws ke around mein, see it from a private partner-public partnership through, and see from a lens of NGOs and involvement of citizens and things around that. So technology always have a perspective while you're giving an answer. Technology issues is lack of e-codes, although is there, but it's not adequate. Infrastructure it's low. Then we have the digital divide. Local languages, these are not represented in a lot of our technological websites and everything. That's also a gap. E-courts, there's an famous case, Swapnil Tripathi. Versus Union of India, which talks about how e-courts and live streaming is very essential. So that's also one of the unique court judgments that you can keep in mind. Technological, there's also like have data for this. Like every point you're writing in your micro notes have a data as well, wherever you're collecting it from. I mean, in Smash Notes, you'll get a lot of these points as well. But to just mention, this has been told in one of the speeches by CJI that 38% of subordinate courts have no VC arrangement with jails. No, only 38% have, wait, the data was, only 38% of the, the subordinate courts have video call arrangements with prisons, and only 14% have with medical offices. That shows that yet we are not there. The technological infusion in Indian judiciary is not yet there. Legislative becomes, and now I said that from policy point of view, you can always do. Legislative, you can have the criminal justice system that we have now. That is too archaic. For example, 67% of prisoners are under trials. We have archaic laws. Example, marital rape. We have sedition and their provisions also, which talks about that, because lack of ambiguity around that also creates a backlogs for Indian judiciary. Then another point, this I think would be our D, right? Would be judicial activism and everything around that. For this, we have PILs, the issues, the PILs issues, there is a explosion of court judgments because of this. A lot of redundant cases which are coming for this. We have the Article 142. The Article 142, which is about the complete justice. The Supreme Court can take up and give a complete justice as well. So it has been told that it does a lot of times judicial overreach by yielding that power from 142 as well. And then judicial overreach, you can give a lot of court judgments. Yes. No, judicial overreach is when, yes, against the separation of the power, as seen in cases like, then you give the court judgments. Yes. We had Shyam Narayan case. We have Anu Barnwal case. Shyam Narayan case was when they have said that it is mandatory for Indian cinemas to play national anthem and everybody has to stand. So this is outside the ambit of the judiciary to make a law, something like that. Anu Barnwal case was when the court said they had given a structure that how the election commissioners, including the chief election commissioner, can be elected. They said that there has to be a committee with the role of the Chief Justice of India, the opposition, leader of opposition, and the Prime Minister. But that was overruled and legislation made a law and they did not include the Chief Justice. So they made the Prime Minister, the leader of opposition, and one of the ministers which is selected by the Prime Minister. So Anu Barnwal case was there because before this there was no law which was any proper structure for electing of chief elections commissioners. So that's why they had done, but this is something beyond their reach. So that can be also one of the examples of judicial overreach as well. So that is our point E. And then we have another way to see the lacuna in ADR. ADR is basically alternate dispute resolution, where you have mediation, conciliation, lok adalats and everything. So there you can say ki lack of infrastructure, fundings are very less, political will is also very less there. There is a trust deficit, human resources gap. So that's also one of these points. So you have like, I think around 15, 16 points of issues that you can always write. And when we talked about judicial reforms, use these issues and find solutions for them, and that would be your judicial reforms. So for that, let's say you take one by one. The first appointment in college, if we are talking about judicial reforms, first we take on what basis there has to be judicial reforms. First is appointment and the retirement, everything around it. So what are the judicial reforms mentioned or proposed for that? Like what is it? There's a lacuna in collegium system, right? It's being said that it's non-transparent. The discussions around the collegium is not published anywhere. It's basically judges appointing the judges. So there's a conflict of interest as well. So how can this be rectified? Yes, but then that was struck down. There was a 99 Constitutional Amendment Act, which was again a judicial review example. That you can also give an example of how this judicial review is not always sacrament and is not always healthy. But there is the second ARC, and a lot of law commissions have also proposed for national judicial commissions, where you have a search committee as well, where you find out that who are the eligible for transfers and everything. You have eligible pool that they decide, and then probably the collegium can take a decision. So a lot of reforms around that is also one for appointments. The second, again, infrastructure. N.V. Ramana, the ex-CJI, he had also proposed for National Judicial Infrastructure Authority, more digitalization and bring e-courts, facilitating the subordinate courts. That becomes one of the solutions as well. What other issues we had? Like, tell one issue, then we discuss about the reform. Yes, infrastructure is talked about. National Judicial Infrastructure Council has to be done. Bracket may give N.V. Ramana's recommendation. Similarly, we had about for retirement. The Law Commission has also proposed that the age of the Supreme Court and High Courts be increased from like the present 65 to 68 and 62 to 65 respectively for Supreme Court and High Courts. We had a very recent case where one of the High Court judges after his retirement joined a political party. So that was also criticized from various sectors. So it's always recommended to have a cooling off period. So that is also one of the reforms. It should be structurally and institutionally be made somewhere. Then a very, very important judicial reform where you can get a separate question as well. All India Judicial Services. So this can be done using Article 312, similar to the All India Services, that we have All India Judicial Services for the subordinate like judiciary, where you have a uniform structure across the country, how we are doing the talent hiring and everything in judiciary as well. The perks, pays, allowances, everything is more uniform. You can retain the talents more. The serving conditions can be made improved. And the coordination between the states can also be made better, because as seen in All India Services in IAS and IPS as well. Similarly, All India Judicial Service is also one of the proposed retirement. So we talked about appointment, which is collegium reform. We talked about All India Judicial Services. What else did we talk about? Retirement. Retirement, you have the period of joining anything else, like basically post-retirement roles / the age. Next, we had infrastructure. Infrastructure could be technical and non-technical, and there we talked about National Judicial Infrastructure Authority, which was given by N.V. Ramana. What else? Like, what are the other areas? Like, think from the perspective, everything that it issues. ADR becomes, there was an issue, right? And the entire point. So, reforms in ADR. How the more permanent lok adalats could be found out, more skilling, more finances and funds there. So, things around that can be also one of the reforms. Technology infusion. You can give a lot of apps which are being like now followed. There is something called LIMS, Legal Information Management System. You have something called SUVAS, SUPACE. So these integrate a lot of OCR and AI in the form of in Indian judiciary as well, e-courts as well. So these are the reforms for technology that you can have. Next, like the issues, we talked about representation, we talked about vacancies. So those are the reforms that is also required. We had delays that we had talked. For that, we could have principle of maximum 3 adjournments. Instead of like having Tariq pe Tariq, Tariq pe Tariq, we just have 3 Tariqs, not more than that. So more or less, these are the reforms. There's another one also can put out. This is given by P.N. Bhagwati. He talked about Indianization of judiciary. Where he talked about the use of local languages be made more frequent here. There's always you can give about legal aid and legal education. Point about that. So these are some of the few reforms that you can have. Give a data, article or court judgment with wherever relevant where you can give. But you have seen every point we discussed in issues. उसी issue के point से you just find out the reforms and you can like have it. Right. The benches. Yes, that's also one of the reforms. The SC benches. Regional benches of Supreme Court. There's another reforms which is proposed is for sealed jurisprudence. We had seen in the case of the cases around Rafale deal as well, where the governments, or in Pegasus case as well, where the evidence and everything is not made public and given to the judge who is leading the case as well. But that also defeats the entire ethics of transparency, judicial ethics as well. So that's also one of the reforms that is also desirable. But when you're writing judicial reforms, always mention in Mullah Committee and Malimath Committee, where they have talked about a lot of things. They have talked about prison reforms. They have talked that more number of judges are important. There is a number of the adjournments has to be minimum. So they have talked about a lot of things. So they cover a lot of judicial reforms that we discussed. So you can always put ki conclusion mein as the reforms which have been proposed by N. Mullah Committee and Malimath Committee can be given more importance in practice as well. So that covers more or less the reforms part of it. Another one thing which is important in judiciary is the basic structure. You can get a standalone question for basic structure, the entire idea. But for there, 3 things that is important to remember. One is the evolution. The starting from all the cases to Golaknath case and everything till Kesavananda Bharati case, and then to Minerva Mills case and Vaman Rao cases, and then how basic structure has been used in a lot of things, SR Bomai cases, AR Silo cases, all that you can write. Then you can write the criticism of it as also. The criticism of basic structure could be, like anybody, like what do you think are the criticism for basic structure? Yes, there's no definition given to basic structure. What else? Sovereignty. So yeah, use the term parliamentary sovereignty. And judicial overreach also at cases, it can have it. So, yeah. Yes, so the people making the decisions are not the representing the people through elections. So that's also something. Or is an elitist concept because few people taking decision on and legislature is not taking. Defeat of separation of powers. So all these things that you can always mention when you're talking about basic structure. But there will be also, you have to write the importance of it. You'll have to understand how through basic structure democratic ideals have been restored. So lastly, there is a question how judicial independence is necessary for democratic ideals to flourish. Similarly, you can have how basic structure is necessary for democratic. So think from the perspective of everything what has been told as a basic structure. Think about the constitutional safeguards. Then think like tell ki the constitutional morality, it cannot be altered because we have something like this as given in Minerva Mills case and Kesavananda Bharati case. Then we saw ki how free and fair election is important, which was given in a lot Rajnarayan case, I think. No, after that a lot of free and fair election cases has been given. Then when SR Boumaier case, we had federalism, which tells about that, and so how federalism is important for democracy. Similarly, Ayat Silo case takes about judicial review as a basic picture. So do not give headings as Ayat Silo or so and so cases. Tell what are they talking about, and then give an example through a court judgment. Court judgment should not be a hero of your answer, but a supplementing element to it. But indispensable actor in your point. But but while you are framing your answer, think from this lens. Everything that you would have read through that, what are the essential features? There's secularism is also there. So all these things, protection of minority rights and all. So us angle se you analyze and give your writer answer. I think next we'll do a PYQ, and then we'll discuss if we have time for other topics as well. So there was a question on last year, I think first question itself probably. Constitutionally guaranteed judicial independence is a prerequisite of democracy. Basically talking about independence of judiciary is necessary for democracy to flourish. So, and the first word is constitutionally guaranteed. So, one, you have to understand, you have to give more emphasis on what is written in Constitution. The judicial independence, which is enumerated or written in few of the articles. So you have to heavily depend on constitutional articles first. And you have to not only show that there is Indian judicial, judicial independence in Indian Constitution. You have to show that how does that help in democracy to flourish. So that is a demand of the question. You'll have to show how democracy prevails because of Indian judiciary, the independence of Indian judiciary, and show that it is constitutionally which is mandated. This you have to take care of. But when you're talking about a lot of people I talked to for this, that what they had written, a lot of people just had a very myopic view in keeping this, like, what do you understand? Like, what is independence of judiciary? What you would have understood? From executive, right? Separation of power, Article 50. That's what you understand, right? Majorly, yes. That is what is called the independence of judiciary, separation of power, Article 50, the essence of 50. But if this is a myopic view of taking this answer, it's nowhere talking about from executive. It's taking judiciary being independent. So judiciary can be independent, not just from executive, but from everything else as well. That it could be independent to make any laws or make any legislative processes. It is also independent to review its own judgments as well, or create new doctrines. There is independence from there. So these are also the areas, or independent enough to make policies which is betterment for the social justice perspectives. So these are and this is how you also show it helps in democracy to flourish. A lot of people just kept it separation of power, separation of power, separation of power. It is. 50% is talking about separation of power, but the rest 50 is also talking how Indian judiciary is independent enough to take decisions on its own. That also is about Indian judiciary being independent. So always think beyond what a basic answer would look like. Yeah, yes. No, it's not intro. Intro should be either Article 50 you can try, or any quote on, because Keshav Bharati case was not talking about, it was in a way, but not, we usually talk Keshav Bharati case for basic structure and not for independence of judiciary per se. Yeah, so you can have it a point, but not necessarily as an introduction. Introduction, you can put a quote, like us time pe I had read somewhere, since there was collegium cases and everything, so the Chief Justice had said that Indian judicial independence forms the cornerstone of Indian democracy. So that was one of the quotes that I started, as said by the Chief Justice D.Y. Chandrachud, this, and as you can see in constitutional articles as well. Then the first point was Article 50. So the first point is separation of power. But separation of power is not only Article 50. This is from executive, right? What are the other articles that talks about judicial, like the separation of power for Indian judiciary? It does, but it's not exactly from separation of power, right? They're independent. It's not from executive, right? Like there's one way in which executive cannot hamper the working of judicial. There's 121 and 211 article, which is basically that in this one in Lok Sabha or like Indian Parliament, and this is state legislature, the conduct and the proceedings of the courts cannot be discussed. So these are basically the tenets that talks about the separation of power for Indian judiciary. Then second, there is absence of politicization. In appointment, in service condition, or in their salaries and allowances, as done by Article 124, plus the collegium system. So these also gives them, and you are writing constitutionally guaranteed, right? So these articles become extremely important because they're telling these are constitutionally mandated. Article 124 talks about their appointment, their removal. Their removal has to be done. There's a specific provision for misbehavior. They can be impeached. The impeaching process is very complex. The collegium system does not have an involvement of executive. So that gives them independence as well. So that's the second point. The third point could be like they are independent enough to, like the writs one. Sorry. Judicial review. Like they're independent, like Article 13. So they're independent enough to declare any judgment null and void. I can give a lot of example for that. NAJSC cases is there. There is Sreya Shangal cases for judicial review. IIT Silo case, very famous for judicial review. So supplement this with court judgments. Every point of this. Yes. Conceptualizing constitutional morality. So when you put phrases like this, that adds up the value as well. Then you can give example, basic structure, and Kesavananda Bharati case. So these are basically the ethos on which the principles and the values on which our constitution runs. So everything that you see in preamble, that forms basically the soul on which the morals and ethics on which our constitution is framed. That is constitutional morality. So what guides the major philosophy and ideals of our constitution to ensuring the rights of the people, liberty, fraternity, and justice to be ensured. Checks and balances, there's no excesses of government. So these are the constitutional morality, the very core foundation. Yes, since preamble is a representation of our constitutional morality, so that way you can understand that that's what you are highlighting. Then fifth, filling legislative void. So in answer, you write like this, like the heading, give a box, and then write it. How does it fills legislative void? Article 142. It can basically, through Article 142, they can do complete justice, and when there is a legal vacuum, they can make laws and principles as well, which was seen in a very famous case. Yes, Vishaka guidelines. During that time, we did not have the Post Act. Same we had for Olga Tellis case as well. There was a right to livelihood, which was made a part of right to life and liberty as well. This is for slum rehabilitation and all, very famous case. That also is one of the cases as well. So then you can show It is independent to review its own judgment. You can give a lot of examples. You can give example of Kesavanandi Bharti case where you can talk about from Golaknath to Kesavanandi Bharti case, or you can give about Nalsa judgment or the Naftesh Johar judgment, because initially the court has upheld that the section 377, but later in Naftesh Johar it removed that as well. So and then you a line will there itself, right, and thus held in uplifting the voices of the marginalized, where you show that democracy ideals are being followed as well. Then, what other points that you can see, that what other ways it is independent enough? What are the other ways? See from the articles, what articles were seen. Yes.
Okay, it will be dependent on the city, like when citizen pressurize, usually to take some stand on some issues, doing protest.
So tell me what article that you can say the court should not succumb to the. I understood it, but you have to find out an article for that or any case for that. Yes, I can't also come up with one thing, but like, for example, we had a lot of outcry for the recent Pune case there as well, but the court still led into the policies of Juvenile Justice Act as well and did not succumb to what is the general consent of the public outcry. Yes. Yes. So, but you show that it's independent. So the court follow what is there as a part of the legislation. Similarly, you can show same-sex marriage, even though there was an outcry for legalization. They say that since there is an absence, so they cannot take this because they do not have the power to reinterpret the Special Marriage Act and include the LGBTQ community as well. So they did not succumb to the citizens' outcry as well. But there are other ways, like how they have become progressive. So even in spite of not having, but having such example like this is a very far-fetched point. You will always have a direct point. Like you can always have a positive attitude to it. Like for example, it's being progressive in terms of Nalsa judgment or in terms of triple talaq cases, Sabarimala cases, in which it had ensured its independence to ensure the progressive ideals get fulfilled and democracy, this is where it's manifested. Then also fairness in democratic institution. How? Governor, everything that we read starting only, we are utilizing that knowledge for CBI, for elections. For governors, you say that what are the court judgments for which they have had for governor. For CBI, they had Vinit Narayan case that talked about the transparency in appointments and the tenure of CBI. For elections, there is Lily Thomas case. There is ADR versus Union of India, PIL versus Union of India, a lot of them. So it restores the democratic ideals to this as well. Then very important, PIL. But the democracy and PIL goes hand in hand. So that is also a dimension that you can have as well. And if it's a 15 marker, you can have a way forward and tell ki even though there is a lot of independence, but there's issues with it. You can write the issues of collegium. You can write the issues of ki cooling off period has to be there. Post-retirement things you have to write. And there is judicial misconduct, judicial overreach because of the using judicial independence. So that has to be taken care. Conclusion also could be given because in separation of power, the philosophers Aristotle and Montesquieu advocated for separation of power. The conclusion either could be quote or could be something like Aristotle and Montesquieu as propounded, advocated for separation of power. So Indian judiciary follows something like that. So instead of just writing a generic article, you can generic statement, you can give a bit of value addition as well. So Apart from Indian judiciary, for anybody who's writing for 2024, things that you have to keep in mind is one, the ADR. ADR could be a question in itself. Everything around ADR, what are the ways in which ADR is being implemented, the different ways, mediation, conciliation, and the 5 ways in which ADR is practiced. What are the lacuna in ADR? What is the lacuna in Lok Adalats? Who are eligible in Lok Adalats? Things like that. Next, we have tribunals. The growing, like tribunals is always a controversial way. So issues with tribunals, reforms in tribunals can become a separate question as well. Next, what we could have is also representation, the women representation of disprivileged community representation, and another one which could be also there, the Chief Justice is extremely vocal about is the issues of subordinate courts in terms of everything, in terms of the appointments, representation, infrastructure, promotions, lack of e-courts, everything. Subordinate like courts also becomes one of the crucial ways, like one of the topics that you have to prepare thoroughly as well. So, more or less these for judiciary rely on a lot of articles, rely on court judgments, and keep these conclusions and all ready. And ek do quote keep ready for Indian judiciary and quote it as an example or conclusion if you are not getting anything very, very relevant. So, I think that's what we covered. You can, and also judicial review and judicial outreach that you can also prepare. Like what are the cases for judicial review? Cases in judicial outreach and judicial activism and PIL. That is a one concept that you can prepare also full-fledged. You have that in Smash Notes, very concise way, but give more focus that as well. So that's it. Thank you.